morning. Good morning. Appreciate everybody being ready to go a little bit earlier today. Welcome back. We are ready to go ahead and proceed with the closing arguments in the case from the state. Ms. Dunikoski.
Thank you, Judge. All right, good morning, everybody. Good morning. Good morning. All right, so yes, the state has another 2 hours to speak to you. Now, some of you may be thinking, please, no, I understand this, I get it, I've got it. But the defense got up here and gave you a lot of information, and the person sitting next to you might have questions that you don't know. So when you get back there in the deliberation room, I want to make sure that I've covered everything so that we're all on the same page as far as the facts and the law go. So what we're going to do right now is we're going to get back to the basics. Okay, we're going to take it back down, we're going to apply the law to the facts, and that's what we're going to do. We're going to walk through this right now. So the burden is on the state to prove this to you beyond a reasonable doubt. Now, Ms. Hood, Laura Hood got up here yesterday and said, you have to be certain. That's not true. What it is it's the doubt of a fair-minded and impartial juror honestly seeking the truth. Not seeking doubt, not beyond all doubt, or to a mathematical certainty. And that's what the judge is going to charge you, okay? All right? It's just beyond a reasonable doubt. In other words, do you think they committed the crimes? Okay, if you go, yeah, I think they committed the crimes, you're good. That's all you need. Now, the defendants have raised what we call affirmative.
I'm going to object to that description of what reasonable doubt is. It's clearly not the law. And there's cases recently about...
Objection.
Okay.
The court's going to charge the jury on the definition of reasonable doubt. That is the law that will be provided to the panel. And again, if we could just have everybody argue or in argument, make sure that you are referring to the law that the panel will be charged with so that there's no confusion about the standard that should be applied. Thank you.
The doubt of a fair-minded and impartial juror honestly seeking the truth. Not seeking doubt, not beyond doubt, or to a mathematical certainty. That's what the judge is going to charge you. Okay? Once again, if you believe they have committed these crimes and the state has proven it to you beyond a reasonable doubt, you are authorized under the law to come back with a guilty verdict on all the charges. It's as simple as that. Now, in this case, the defendants have raised an affirmative defense. And what does that mean? An affirmative defense means, hey, even if you think we really did these things, because the evidence is sufficient to say, yes, we did do these things, the 4 felonies in the indictment and the murder, hey, we have an affirmative defense which justifies us doing that. For the murder, it's self-defense. For the other charges, it's citizen's arrest. So here's the thing. You find they didn't commit a citizen's arrest. That's not what they were doing. Under the law, they didn't meet the criteria. Okay, and I want to remind you guys, ignorance of the law is no excuse. It's not like, well, they were probably mistaken. You can't be mistaken about the law. If you're going to take the law into your own hands, you better know what the law is. So if you find they were not doing a citizen's arrest under the legal standard, okay, the judge is going to give you, well then it takes it out of self-defense for the homicide, and that means they're guilty on all the charges. Right? It's as simple as that. So count 1, malice murder. Remember, premeditation is not required, and the state is not required to prove motive. All right? You may find malice when there does not appear to be significant provocation and all the circumstances show an abandoned and malignant heart. Okay, I want to be real clear. The state is not saying that Greg and Travis McMichael ran out of the house to go murder somebody right then and there. We all know that's not how it works, right? Okay, what happens? Let's give you an example. I'll make up an example. She's leaving him, right? They're getting a divorce, and she's there to pack up her stuff, okay? He's not at the house to murder her, right? No. But what happens? She's packing up the stuff, they start arguing, they start bickering, then it starts into shoving, then it's if I can't have you, nobody can have you. She's thinking, oh my God, he's an idiot. She's taking the stuff out to the car. He goes up and kills her, shoots her with the gun. Okay. It started out one thing, and it escalated and escalated and escalated. That's how you get to the murder. So don't be fooled, okay? The state's not saying they left the house to go murder Ahmaud Arbery. What happened? They left the house to go investigate, right? Stop, we want to talk to you. Where are you coming from? What did you do? What's going on, right? And then what happened? Mr. Arbery ignored them, okay? He took off running. He wouldn't do what they were commanding him to do. He wasn't obeying their orders. Why? Well, under the Constitution of the United States, he didn't have to do anything except walk away. In this case, he ran away. And they chased him. They backed up on him, and then they followed him down Burford. You saw the Night Owl video repeatedly yesterday when Mr. Goff was here. At that point, I mean, let's face it, to Travis and Greg McMichael, that was a big go jump in the lake. I'll use polite language. I mean, wasn't it? Here they are, ex-law enforcement, Coast Guard. We're demanding that you stop and talk to us. We have questions. Stop right there, talk to us. And he ignores them, basically telling them, yeah, I'm not doing it. And it starts escalating. They start getting mad. Oh yeah? And then all of a sudden, Bryan pulls out. Then it's like, oh yeah, we'll go around and we'll cut him off over here. We'll go get him. Now they want to get him. Now they want to stop him because they're mad at him. He has totally ignored them and run away from them. And how dare he do that to these two people? Okay? What right did they have to stop Ahmaud Arbery? What right did they have to go ahead and demand a fellow citizen stop and talk to them? And then use pickup trucks to try and cut him off and force him to be detained right there on Burford. None whatsoever. So when we're talking about malice murder, we are talking about the fact that this can happen. And the judge is going to charge you on this. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. How do you see malice? Well, you can consider it as reckless disregard for human life. You bring your 12-gauge pump shotgun with you, ready to fire. You point it at a man you know is unarmed. I mean, you think they couldn't tell with those baggy shorts that he didn't have a gun on him? Who's being forced toward you by Mr. Bryan and his black Silverado, and then you go ahead and intercept him and pull the trigger without a thought. Abandon a malignant heart, reckless disregard for human life. And they're in it together. Greg McMichael and Travis McMichael are acting together in concert in the truck. Their actions are all together. They're parties to the crime. Even though Greg McMichael is in the back of that pickup truck on that 911 call, when Travis pulls this trigger, he is still responsible because he's a party to this crime. Because without Greg McMichael, this would never have happened. Now, felony murder, once again, is based on the 4 felonies. Now, the felony murder is you're committing a felony. There's no intent to go ahead and kill the person, but because you're committing that felony, someone dies. Okay, let's not be fooled. We're not talking about but for his parents getting married. That's the red herring. What are we talking about, ladies and gentlemen? But for the felony. Okay, that's the thinking. But for the criminal attempt at false imprisonment. But for the false imprisonment. But for the aggravated assault with the motor vehicles. But for the aggravated assault with the shotgun. He wouldn't be dead. That's how you think about it. Look at these crimes and ask yourself, okay, if we take that out, would he be alive? It's real simple. The answer is you can't take out any of these crimes. You take out any one of these crimes that they committed, and he's still alive. All of the underlying felonies played a substantial and necessary part in causing the death of Ahmaud Arbery. What do we have? Aggravated assault with a shotgun. Pretty simple. The aggravated assault was continuous. Started with pulling that shotgun up. Ahmaud Arbery was 30 to 40 yards away. Not an imminent threat at all. And what did it do? It ended with the pulling of the trigger, shotgun blast here, pellets right here. Did that felony contribute? Of course it did. It's the cause of his death. Aggravated assault with pickup trucks. I want to be real clear about this. You do not have to hit the person with the pickup truck. The judge is going to charge you that actual injury to the alleged victim need not be shown. What has to be shown? This. Were the defendant's actions such that it placed Ahmaud Arbery in reasonable fear of immediately receiving a violent injury? What did Mr. Bryan do? He actually ran him into a ditch. Check. I mean, Mr. Bryan right now, aggravated assault with his motor vehicle, check. Felony murder, check. Because this contributed to his death. This played a substantial part because it put Mr. Arbery in reasonable fear of Mr. Bryan and that truck. So what do we know? We know that Mr. Arbery was running back up Holmes when Mr. Bryan came back down, and he had to turn around at that blue mailbox. We don't see him turn around, but see how far he is at that blue mailbox, and he heads back toward the white truck. If he wasn't already in fear of Mr. Bryan and his Silverado, would he still be alive? Yes. But because of what happened over on Burford, because of the criminal attempt at false imprisonment and this aggravated assault, Mr. Arbery's dead. False imprisonment. You violate the personal liberty of Ahmaud Arbery. You unlawfully confine and detain him. Well, how do you do that? Well, you chase him down with a Ford F-150 or a Silverado. And they did confine and detain him on Holmes. Ladies and gentlemen, come on. We've looked at this. All right? What do we got? We've got Mr. Bryan chasing him up Holmes. Now, yeah, this line doesn't go far enough, because what did Travis McMichael tell the police? I stopped a few houses down, got out of my truck, and shouted at him, "Stop, stop." Now, he denied it on the stand, but that's what he told the police in his written statement, the one he had an hour to fill out, right? So Mr. Arbery got this far and had to turn back around. Then he goes back this way. Then he has to go back down this way, because now he's turned around. Now he has to come back this way once Mr. Bryan turns around. He went up and down this street at least 4 times. I mean, come on. Confined and detained on Holmes. That's false imprisonment. Up and down 4 different times, right there. Criminal attempt. You saw the Night Owl video. You saw how fast they took off after him. I mean, Gregory McMichael's yelling, "Cut him off, cut him off, cut him off." Travis denies that he did anything to cut off Mr. Arbery. Doesn't even say he pulled in front of Mr. Arbery. But for some reason, Mr. Arbery turns around and runs back. You decide what to believe. But what was he trying to do? What was his intent? He told you what his intent was. Our intent was to stop him. Can't stop somebody. United States of America. Okay? People are free here. They had no authority to demand that he stop. And they're yelling at him, "Stop, we want to talk to you." And he's running away. That's the criminal attempt by the McMichaels on Burford. Now, of course, we know the criminal attempt at false imprisonment on Mr. Bryan. He pulled out and pushed him, shoved him, did whatever, got him into a ditch. Now, those actions on Burford, did it put Ahmaud Arbery in reasonable fear of receiving bodily harm? Yes. So now what's he doing? He's running away from them. For 5 minutes, he's running away from them. If they hadn't put him in reasonable fear of receiving serious bodily harm so that he ran away from them, would he be dead? The answer is no. Therefore, that substantially contributed to his death. Because why? All right? Where did he go? He went up Holmes. Now, this whole thing of, the reason he didn't really run out this way is Mr. Albenzi was down there with a gun. Nobody has x-ray vision. Mr. Albenzi had the gun in the pocket of his overalls, okay? And what do we know Mr. Albenzi did after all this? He went home. Remember? He walks back and he goes on home. Goes on home here. So this idea that Ahmaud isn't going to run this way because Mr. Albenzi is out there, we don't know what's in the mind of Ahmaud Arbery. Not at all. But what did Mr. Bryan do? Well, Mr. Bryan got in front of him and then went to back up at him, and that's when he turned up Holmes. Those are the words of Mr. Bryan. I pulled in front of him, I backed up at him, and that's when he turned up Holmes. Therefore, the criminal attempt at false imprisonment substantially contributed to the felony murder. Based on that alone, ladies and gentlemen, criminal attempt at false imprisonment, guilty. Felony murder for that on all of them. Mr. Bryan included, and the McMichaels, guilty on felony murder. So, but for his actions, would Ahmaud still be alive? If he had not helped to stop Ahmaud with his Silverado, would Ahmaud still be alive? And the answer is, yes, he would have been. That's all you got to think about is, well, what did he do to contribute to help the McMichaels? The answer is yes. Mr. Bryan played a substantial and necessary part in causing his death. He is responsible for the murder of Ahmaud Arbery. All right, so that brings us to self-defense. All right, I'm just going to go over this quickly. I want you to know what the basics are, the essentials, okay? Because self-defense really applies to the aggravated assault with the shotgun, okay, and the murder charges. So what have we got? One can use lethal force in self-defense, but only under certain circumstances. You can't claim self-defense if you are the unjustified initial aggressor, meaning if you started it. Who started this? It wasn't Ahmaud Arbery. If you're committing a felony against that person, once again, we're back to our convenience store armed robber. He doesn't get to defend himself against the clerk he's robbing. He doesn't get to claim self-defense. He's committing a felony. In this case, they committed 4 different felonies, including the aggravated assault with the shotgun. They started it. They do not get to claim self-defense. And then, of course, provocation. You can't force someone to defend themselves against you, so you get to claim self-defense. This isn't the Wild West. No. So there's 3 instances where the defendants don't get to claim self-defense, and they committed all of them. So once again, initially provokes the use of force against himself with the intent to use such force as an excuse. No Wild West. This is the important one. Cannot commit aggravated assault with a shotgun, with trucks, false imprisonment, or criminal attempt at false imprisonment. Any of those. Not justified in using force if you're doing any of those things. They were doing all 4 of them. And you're not justified in using force if that person was the unjustified aggressor. You can't start it and claim self-defense. And they started this with their driveway decisions. So here's some main concepts. The defendants had to believe the deadly force was necessary. There were no other alternatives. Pointing a shotgun at somebody. There were a whole bunch of other alternatives to that. That belief must be reasonable. And once again, that's reasonable for everybody. That reasonableness applies to you. That reasonableness, there's no special exception for previous training in the Coast Guard or law enforcement. The reasonableness standard in Georgia applies to everyone equally. The danger to yourself has to be imminent, meaning I am about to get killed. Not some guy I've been chasing for 5 minutes is running at me. Can't use excessive force. The minute it's excessive, self-defense goes out the window. The defendant's reasonable belief must be what prompts him to use force. What prompted Travis McMichael to pull up that shotgun? He wanted him to stop. He was trying to get him to stop. Oh yeah, you're not going to stop for me and my dad? Up comes the shotgun. Now you're going to stop. Okay, you're not going to stop. You're going to go around the truck. That's fine. He goes to intercept him. He's not afraid. He moved toward Mr. Arbery. He moved toward Mr. Arbery with the gun. He's not afraid. You gotta act out of fear. You can't be acting out of anger. That this guy won't stop and talk to you and won't obey your commands. Okay. What was there to be afraid of? Well, let's see. Ahmaud was wearing a t-shirt and cargo shorts that were so baggy he has this big belt loop out here. Let's see what else. Didn't have a bag or a backpack. So, yeah, doesn't have anything that he's carrying. He was running with his hands empty at his sides. ran away from them for 5 minutes, did not have any weapon, nothing on him. Didn't say one word to them, didn't threaten them verbally, didn't say, oh yeah, didn't say anything. And he had no help from anyone. So what's there to be afraid of? He went this way, he goes this way, he goes that way. And you see Travis McMichael move down to the center of the street there, blocking his way. He's trying to get away, and then, oh, look, he's going to go this way. And he does. And he goes around. And what do you have here? Travis McMichael going to intercept. And that shadow underneath there, I mean, you can have the stills back there. We printed some of them out. That shotgun is pointed right at him. Right at him. Okay? So when he gave the police that story about, oh, it was at Port Arms, and he was striking me and hitting me and striking me and hitting me, and I finally, had to do this. That's what he told the police. A bunch of lies. Shotgun, shadow right here. Okay? Here's the other thing, ladies and gentlemen. Lawyers aren't good at math. I don't trust you guys are. What did the ME say? This arm on Ahmaud Arbery was 26 inches. This arm on Ahmaud Arbery was 25 inches. And the barrel of that shotgun is over 28 inches. Do the math. Did he hit him? Did he punch him? Did he strike him? When the shotgun's like this? It's easy. Do the math. This is what Travis McMichael did. There's no fear here. There's only anger. Remember, it's a standard of reasonable beliefs that the force used is necessary. Do you really believe he had no other choice but to use his shotgun? Is that what you really believe? No other choice. What are the alternatives? Well, the first alternative is don't start this. I'm going to tell you something. My husband, he always tells this to our three nephews, David, Ben, and Sam. And what he says is, there's some rules for life. You know what those rules are? Don't go looking for trouble, because you will find it, and it is not going to turn out the way you think it is. What he's really saying to them is, don't be that guy who starts the bar fight and goes, let's go out in the parking lot. That's what he's really saying to them. But it's a life rule. You go looking for trouble, and what's going to happen? So don't leave the house. Here's an alternative. Call the police. Don't chase down strangers to confront them. Don't go after pedestrians in your truck. I mean, common sense tells you, you pull up in a truck on somebody who's like a pedestrian who's out for a jog. I mean, I don't know, are any of you runners? You ever had a strange truck pull up and have some people start yelling at you? Would that startle you? I don't know. We don't know what was in the mind of Ahmaud Arbery. But, I mean, what do you think? Did it cause some fear for him? These strange men pulling up in this truck and then not relenting and not backing off? This was 3-on-1. How about some empathy? Remember leaps? Listen, empathize. Where is Travis McMichael's empathy? Where's Greg McMichael's empathy? Where do they go? Wow, I wonder what I'm doing to this other person. I wonder what it looks like from their point of view. I wonder if we might be scaring or startling this person. I wonder if it may be so bad that they might react in a negative way. Where's the empathy? How about don't bring a shotgun with you? This is really easy. Call the police. Because what did Officer Rash want? Remember Officer Rash? He said he wanted them to be witnesses. So call the police. Follow behind Mr. Arbery at that 2 miles an hour. Where's he going to go? They could have followed him all the way back to Fancy Bluff and Boykin Ridge. On the phone going, he's turning left. He's turning right. Ooh, okay? That was a real easy choice, but did they choose to do that? No, they confronted him. They chose to confront him. They didn't need to. They didn't have to. They could have followed. He's a jogger. How fast is he going? Don't point a shotgun at people unless you're going to kill him. Don't point a shotgun at people unless you're going to kill them. How do we know he intended to kill them? He pointed a shotgun at him. How about you stay on the driver's side of the truck? Don't go around to the front of the truck. Real easy. All right, so let's go ahead and take a look at citizen's arrest, because this is really important. The law of citizen's arrest. Okay? So first off, the defendants never ever said citizen's arrest. They never ever said we're making an arrest. They never said we saw him commit a crime. So ladies and gentlemen, where in the world did the citizen's arrest thing come from? Because it didn't come from the defendants on February 23rd, 2020. Where did it come from? So what is the law? A private person may arrest an offender if the offense is committed in his presence. What does that mean? Right here, right now, I saw you commit an offense. Okay? I saw you criminally trespass on that property right here, right now on February 23rd, 2020. I saw you commit a burglary. I saw you commit whatever crime it is, it's in your immediate presence. Or within immediate knowledge. Okay, we talked about that. The guy at Walmart is not standing next to the shoplifter when she shoplifts, but in real time, what's he doing? He's watching it. We're not talking about videotapes. You can't watch a videotape from November and then have it in your immediate knowledge. Okay? Remember, the judge is going to tell you it's synonymous. It means the same thing. Meaning, in your presence or immediate knowledge means immediately you know because you saw it. That's what that means. That doesn't mean watching a videotape on February 11th with Officer Rash in front of 220 Satilla Drive. That's not what that means. A private person may arrest an offender if the offense is committed in his presence. Did Ahmaud Arbery commit any offense in the presence of any of these defendants? The answer to that is no. Boom. Citizen's arrest is gone. But yes, I am going to continue because there's some more caveats. If the offense, the one that was just committed in your presence, is a felony, do you get why they're trying to make Ahmaud a burglar so desperately? Because if all he's doing is criminally trespassing.
Your Honor, again, I don't like to interrupt closings, but this is not an accurate statement of the law that the court is going to give this jury. The parenthetical is not accurate.
The parenthetical is mine. Totally mine. Okay?
Well, I've made an objection, though. I'm asking for a
Let's just
ruling.
explain. Yeah, the parenthetical is what the state is arguing. The rest is the charge of the court. The charge is going to be provided to the panel, and with the same explanation I provided a little bit earlier on what the law is going to be, the court is going to provide you the law of the case. Counsel, you may proceed.
Thank you. So, okay. The first sentence is, a private person may arrest an offender if the offense is committed in his presence. Okay? You can arrest if the offense is committed in his presence. If the offense, and that's my parenthetical to remind you, if the offense, we're talking about that offense, the one that was just committed in your presence is a felony, and the offender is escaping or attempting to escape, right then and there.
Judge, that is not the
No.
law that the court's going to give, and we've had this discussion.
It's a
talked-
misstatement.
It's a misstatement of the law. We would object.
I join in the objection.
It's noted.
You understand this is my argument. The judge is going to give you the law, right? And he's going to have it written out for you, and he's going to read it to you. But this is the state's argument, that the offender is escaping or attempting to escape. The state's position is that what that means is, I saw the crime, I can't chase after the person, I just have to try and arrest them right there. But if it's a felony, and if they're escaping, they're running away, I get to chase after them. I don't get to chase after them unless it's a felony and they're trying to escape. All right? A private person may arrest him upon reasonable and probable grounds of suspicion. That's the state's position.
We have to object and have a conference with the court.
No, we're going to let the state continue. We talked about this in the charge conference. The objection is noted.
We move for mistrial.
Based on the incorrect statement of the law.
Rejoin.
Ladies and gentlemen, if you could please just go ahead and take a step into the jury room.
All right, for the jury.
All right, the court had a charge conference Friday. I was provided a bunch of arguments over the weekend that we are making part of the record. So I understand the objection is being made to the law. I've indicated the law is going to be provided to the panel. I've indicated the court's position with respect to the law. So with that, I'd like to get the closing argument done, but I'm more than happy to hear the motion for mistrial and proceed from there.
Your Honor.
Based on the final draft of the charge that the court provided us, I guess yesterday morning, the court is going to charge that a private citizen's warrantless arrest must occur immediately after the perpetration of the offense, or in the case of felonies, during escape. If the observer fails to make the arrest immediately after the commission of the offense or during escape in the case of felonies, his power to do so is extinguished. That's not what the state's arguing. They're arguing and it's a clear misstatement. The court should simply instruct the state not to argue an incorrect statement of law rather than putting the burden back on the jury to understand what the state's saying, what we're saying, and now what the charge is saying. The court has the power to do so and should do so.
In further support of the motion for mistrial on behalf of Greg McMichael, obviously this is the last word by any counsel in the case, and to argue the state's case, which we're perfectly fine that they're doing, is to argue the facts and evidence as the law applies to them, but not as a misstatement of the law applies to them that we can't correct except by making an objection when the incorrect law is being given to the jury by the state. So there's no way we can fix it. We're asking the court to fix it, not by simply saying to the jury that the law is going to come from the court, which it will, but that this is a misstatement of the law and this argument is improper.
Joy.
State.
Thank you, Your Honor. Yesterday, the defense got up here and argued their interpretation of the law. And I didn't object at all because I knew it was their interpretation of what they believe the law to be. They went through the whole probable cause thing. They called him a burglar. They went through everything. The state didn't object because I understood that this was their position of the law as applied to the facts. I've just made it clear to this jury, and I will again, that this is what the law is, and this is how you apply it to these facts, and this is the state's interpretation of how you read this law, just like they gave their interpretation in their closings yesterday. So we ask that you deny the mistrial.
Onward. Well, no.
Yeah. You can argue the law. You can't argue a misstatement of the law. The state never told the jury, this is my interpretation of law until we objected.
Well, I think that's what was explained in the parenthetical, but the state does need, state needs to clarify that this is the argument based on the law that will be charged and with the law that will be charged, and make sure that we're clear about what the law is that's being charged. There was a debate about this on Friday, and I'm not going to reignite that debate in front of the panel.
We're fine with what the court's decision was on the contemporaneousness of the events. The charge is great. It's the state's argument about what that means that's flawed, and it's fatally flawed.
The state has the right to, just like the defense had the right to argue that what escape means is escaping whatever this temporal period is. I understand the state to be arguing the same thing in a much more limited temporal period. I think the state's got the right to do that. The state needs to be sure, though, that it's clear that that is the argument that is being made as opposed to what the law is. And I think the charge is very clear about that. So the motion for mistrial is denied.
If I may add, the state is arguing that the felony for the second sentence has to have just occurred in the immediate presence of the person seeking to arrest the escaping felon. That is absolutely a misstatement of the law. Even as the court agreed to charge it, that's not even correct. The second sentence does not require the felony to have occurred within the immediate presence contemporaneous with the escape and the chase. That is not the law. That's not the law the court agreed to charge.
Your Honor, you're charging the statute. And the statute are those two sentences. The state's interpretation of that statute is if the offense, well, that is, the offense has to be committed in your presence or immediate knowledge. If that offense is a felony. I mean, that's what it says. If that offense, well, it's referring back to that first sentence. And the state's interpretation is, then that means that felony had to be committed in your presence. The person had to be escaping right then and there. And that's the state's argument to them, that they never saw anyone escaping from a felony that had been committed that day.
That's not what the court's charging.
Yeah, that's not what was in, so the escape, the second sentence the court was charging, which I understood was agreed to, was that if it's a felony and there was an escape, that's the temporal issue that we're talking about, then those steps can be taken to detain or arrest the individual. What I understood the defense was arguing is that this temporal period stretched over some time. And what I understood the state was arguing was, no, that temporal period is limited to what had occurred there, the escape. The word escape was he was escaping from whatever may have occurred that day.
Yes, that is what we're arguing.
Okay, well, that's not what I'm hearing then, because what I'm hearing is, well, if the state limits its argument to that's what the second sentence refers to, an escape, that limited temporal period, then that's permitted. That's what we talked about in the charge conference.
Yes, Judge.
I don't think that is what we argued about by email and all the rest, Your Honor.
Well, that's what I remember, that's what I'm saying.
The state will limit its argument to that.
Your Honor, if it's okay for me to step out just for a second, I will not disturb the jury if they're back by the time I get back.
I could also use a bathroom break. I assume that's what Mr. Hood was looking for.
Okay, let's just take literally 5 minutes and then we'll get back into this.
Thank you, Judge.